come on. I think Anna
Okay.
will probably join this meeting to order at 11:46. I'd like to thank everyone for being here, and just remind, please keep your camera on, and whenever you speak, to announce your name so that we'll know who's talking so we can record it, please. First order of business, Anna, could you call roll, please?
Of course. Bruce Ormond.
Here.
Colleen Thomas.
Here.
Grant Allen. Lance Thomas. Oh, Mr. Thomas, you're muted, sir. Okay, looks like you're still muted. Just give a thumbs up that you're here. And presiding officer Byron Farrell.
Here.
We have a call, sir.
Okay, thank you. For next item on the agenda, I'd like to call on Stephen Leary to go over our training, please.
Thank you, Mr. Presiding Officer. Stephen Leary, Assistant General Counsel. I'll be going through our open government training we're required to give to the board members every year. So I'm going to share my screen. I'll be going through some slides. At the end, I'll answer any questions you have about the training. Oftentimes it kind of goofs up when we try to share the screen, so hopefully this works. Are you able to see the slides?
Yes.
Okay.
Yes.
Apologize. I'm going to enlarge them so you can read them. All right, very good. So this is the open government training, and it covers 3 key statutes that are all open government statutes. They all require transparency in government, allow for public participation, and that's really the key theme of these three statutes that affect the advisory board's operations. The Open Meetings Act, the Administrative Procedure Act, which is also called the APA, and the Public Information Act, which is also referred to as Open Records Act. We'll start with the Open Meetings Act, and that's the one that we probably have the most familiarity with. We're going to go over the nuts and bolts. So the Texas Open Meetings Act, that's in Chapter 551 of the Government Code. It requires that meetings of government bodies be open to the public, and there has to be a notice ahead of time to let the public know what the meeting is going to be about and when the meeting is going to be. The courts have held that the provisions that are in the Open Meetings Act are mandatory, and they're to be liberally construed in favor of this policy of open government. One of the key concepts under the Open Meetings Act is a quorum. A quorum is a majority of the members of the advisory board or committee as fixed by statute. A quorum is necessary for the board to take an official action, such as today, if you wanted to propose those rules, well, that requires a quorum of the board. To take a vote or an official action requires a quorum. And you can meet with less than a quorum. So if a quorum didn't show up today, well, you could still show up and hear comments and that kind of thing, but you can't take official action without the quorum being present. That's why we certify a quorum at the start of every meeting. Another key concept is what constitutes a deliberation under the Open Meetings Act. So the big prohibited thing under the Open Meetings Act is engaging in deliberations with a quorum of members that hasn't been posted in the open meeting. So deliberation is a discussion or exchange among members of a government body concerning an issue within the jurisdiction of the government body. A meeting under the Open Meetings Act, that term is broad. It can encompass more than one type of thing, but it occurs whenever a quorum of the governmental body engages in deliberation or takes a formal action. There are the notice requirements of the Open Meetings Act, and that involves posting the agenda. We're required to provide written notice of the time, place, and subject of the meeting. So we provide this in the agenda. The agenda has to get filed with the Secretary of State's office 7 days before the meeting. And we also post it on the TDLR website. And importantly, during the meeting, we can't engage in discussions about a subject that's not included in the agenda. So it's not a surprise. The public knows ahead of time what it is we're going to be talking about. What about social functions, conventions, and workshops? Keeping in mind that a meeting occurs when a quorum of the government body engages in a discussion about an issue within the government body's jurisdiction, can the board members meet in an informal setting without violating the Open Meetings Act? Yes, you can engage in conversations that are incidental to the event. So if you went to some event about auto parts, you can go there. But what you can't do is discuss something in a quorum that constitutes a deliberation about something within the agency's jurisdiction. So keep that in mind. If you got a quorum of people in the hallway, if you're at an event, wherever you are, if you're talking about something that's within the agency's jurisdiction, you can't engage in those deliberations outside of a duly posted open meeting. The key points to remember: you want to be aware of any situation in which that could happen, where you could be engaged in a discussion with a quorum outside of a posted open meeting. And you don't want to do that. You want to, if there's a quorum of members involved in the discussion, that discussion needs to take place in the open meeting. Beware of the walking quorum. That's a concept that comes up a lot. We'll go more about what a walking quorum is. So a walking quorum is when you start out with a discussion with fewer than a quorum. So you can do this. One reason why we have work groups, and advisory boards will appoint a work group with fewer than a quorum, is so you can develop an idea and have a discussion outside of a posted open meeting, and we can talk about something, and then that group will report back to the board in the open meeting. Well, if you start out with fewer than a quorum engaging in discussion, two of you are talking to each other, and then other people get brought into that discussion. Maybe an email gets forwarded, maybe you call someone else. Well, you may not have a quorum in the conversation at any given time, but by bringing in people that now constitute a quorum, that's what's called a walking quorum. So an example is you have a 5-member advisory board. 2 members exchange phone calls or emails expressing their thoughts on an upcoming rule change. And then you exchange that research with someone else. Well, now you might have engaged in a walking quorum, and that could violate the Open Meetings Act because that discussion is occurring outside of a properly noticed open meeting. So walking quorums can occur in conference calls, video conferences, hallway discussions, even by email, text message, social media. To avoid a walking quorum, you should not meet in small groups and then discuss that with people outside of the small group. And we've covered all of this. Another concept that comes up is what's called polling. So one thing you can't do, or is prohibited under the Open Meeting Act, is to take an informal vote of the board by asking each other for feedback outside the open meeting. You can't do that because you're essentially taking an informal vote, and the vote is required to take place in the open session. So you don't want to engage in polling on the issue with a quorum of members. Some guidelines for open sessions. This kind of board wouldn't meet in a closed session. There are certain times when a government body can meet in an executive session or closed session. That typically doesn't occur at the advisory board level. So guidelines for the open session is you want to limit your discussion to what's on the agenda. During the public comment portion, members of the public can come by and say anything they want. You can set reasonable limits on how long they can talk and the content of what they're saying, but they can come to you with a new concern, something that's not on the agenda. But in receiving that public comment, you really can't respond to it or comment on something that's outside of the agenda. What you can do, though, is set that as an agenda item for a future meeting. And we've covered most of this. To avoid violating the act, you want to limit your discussion to things that are on the agenda. Avoid allowing discussions regarding a previous agenda item to wander off course into new issues that have not been noticed to the public. You don't want to respond to or discuss issues that are raised during public comment that are not on the agenda. And specifically, identify items for future agendas and communicate those items to TLR staff. So when we're getting ready for another meeting, that's the time to tell the advisory board coordinator, tell me, hey, I want to put this on the agenda. So let us know ahead of time to put something on the agenda so that we can get that on the notice that gets posted with the Secretary of State 7 days before the meeting. We really need that more than 7 days, but we want to try to identify agenda items ahead of time. If someone were to violate the Open Meetings Act, there are some civil and criminal ramifications. On the civil side, any interested person, including the media, can file for an injunction in court to stop an action that's taken in violation of the Open Meetings Act. Now, it doesn't come up real often, but that could happen. Also, under the Open Meetings Act, an action that's taken in violation of the act is voidable. So if you were to take some action, there wasn't a quorum there, a court could hold that action was void, and that it could set aside the action that the board took. On the criminal side, there are criminal penalties for knowingly violating the Open Meetings Act. This doesn't come up very often, but we have to tell you about it. If you were to knowingly violate the Open Meetings Act, it could be subject to a fine of $100 to $500 or up to 6 months in jail. Best practices, again, avoid communications that involve a quorum of board members that are outside of the properly noticed public meeting. And during the open meeting, you want to confine the discussion to things that are on the agenda. There are some resources here from the Attorney General's office, more information about the Open Meetings Act. You can also reach out to me or call me with any questions about the Open Meetings Act. I'll now go into the Administrative Procedure Act, which is also referred to as the APA. That's in Chapter 2001 of the Texas Government Code. Now, the Administrative Procedure Act does a lot of things. There's a contested case provisions in it that govern contested cases. There's also rulemaking parts of the APA that deal with how agencies propose and consider and adopt rules. And that's what we're dealing with today, is the rulemaking part of the APA. It establishes standards and uniform practice, and it requires public participation and transparency during this rulemaking process. Now, a key definition under the APA is what is a rule? Because something that doesn't rise to the level of being a rule doesn't have to go through this formal process. A rule is a statement of general applicability that's made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. The definition of a rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. So that's really a key point. When we talk about something being a rule and having to go through the APA, it's something that's affecting private rights or procedures. And it's not just internal management of the state agency. A rule, what we call a rule for APA purposes, that includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. Now, there are various sources for rulemaking. So, as we've seen earlier today, one source is legislative changes. A new law will be adopted. Sometimes that law will actually require us to adopt rules. Sometimes we just kind of want to in response to legislative changes because those changes affect the way we do things. And we have a process at TDLR to bill implementation teams to review bills. And one of the things those teams do is they bring up the possibility or the need for rulemaking. So there's the legislative process. Advisory boards themselves are also a source for rulemaking. So this will come up as one of you might say, hey, I think we need a rule to address this, and put that on the agenda. You can be a source for rulemaking. TDLR staff, we generate ideas for rulemaking. There's a 4-year rule review process that we'll get into, and that the rule that I drafted for today touches on that as well, that every 4 years, a state agency has to review all of its existing rules and re-adopt them. And we can either re-adopt with amendments or repeal the rule, but we have to formally review those rules every 4 years to make sure that they still serve a purpose and they're still needed. And lastly, there's a rule petition process. That doesn't come up real often, but there's a process where an interested person can petition the agency and require us to consider adopting a rule. Next slide. So what is a rule petition? Well, an interested person is under the APA can petition us to make us consider. They can't make us adopt a rule, but they can make us consider the rule, make us put it on the agenda. An interested person is a Texas resident, a business entity located in Texas. It can be a government subdivision. It can also be a public or private organization that's not a state agency, but is located in Texas. This is a flow chart. Now this gets very complicated, but this is a high-level flow chart of what this rulemaking process looks like. You can see it starts out at the idea on the drawing board. You could say that's where we are today, but we're starting with the idea. Then there's some internal analysis and review that goes on. There's a fiscal impact analysis that's done. Nowadays, all rules have to go through the governor's office for approval before we can publish them. So that's another thing that happens. Now, the order of these is a little bit, it varies from time to time. Sometimes that governor review doesn't happen until after the advisory board meets, depending on what the advisory board does. But at some point, it goes to the first advisory board meeting. That's where we are today. That's where you're going to consider whether or not to formally propose a rule. If you do decide to formally propose a rule, then what happens is the rule gets published in the Texas Register for comment. There's a 30-day public comment period. And then ordinarily, it doesn't always happen this way, but ordinarily there'll be a second advisory board meeting to consider those comments that came in and consider whether or not we need to make changes in response to those comments. Ultimately, the advisory board can decide to formally recommend to the commission to adopt the rule. And if you do that, then these rules go before the commission at the meeting. If the commission votes to adopt the rule, then there's an adoption notice that also gets published in the register to let everyone know that there's this new rule that's been adopted. The adoption notice will state what the effective date is of the rules. The rule review process, I just want to touch on that. A few of the things that are in the package that I prepared are rule review rules, but 4-year rotating schedule, the agency reviews every program's rules. We publish in the register a notice of intent to review, and it just lets everyone know that we're reviewing them. The public has 30 days to comment on that. And so people outside the agency and also within the agency can make comments in response to that notice of intent to review. In the General Counsel office, we review those comments that come in. Then it goes before the commission for readoption. Now, the commission can either readopt, adopt with amendments, or repeal a rule. But if it decides to do anything other than readopt the rule, the changes to those rules also has to get published in the register, and there's a separate rulemaking process. So generally what will happen is the commission will readopt the rules, and if there's a need for changes, there'll be a new rulemaking process that will be started to make those changes. If there are changes that are recommended as a result of that rule review, that'll come here to the advisory board to consider. Here's some more information about rulemaking. Again, the Attorney General's office is a wealth of information about this. You can also always reach out to me with questions. Lastly, we're going to touch on the Public Information Act. The Public Information Act, which is in Chapter 552 of the Government Code, is also referred to commonly as the Open Records Act. It creates this presumption that all of the documents and records that a state agency has is open to the public. The public has a right to review it. And it creates some exceptions for things that the public doesn't have a right and can't review. Public information includes electronic communication, paper documents. It includes just about any form you can think of. It includes text messages, emails, and so forth. And again, the Act provides that the provisions are to be interpreted liberally in favor of granting requests for information. So it's a strong public policy behind the law of transparency and openness in government. Now, if we receive a request, now, if someone wants to make an open record request, they should go through our portal, through our website, and submit it. But if we receive a written request for information any other kind of way, we still want to treat it as an open record request, forward that request to the General Counsel Open Records team, because they're very time sensitive. When we get an open record request, we have a limited amount of time to respond back as to whether or not we're going to provide the records. And if we're going to assert that those records aren't public or parts of them should be withheld, there's a deadline for us to make that argument and request an Attorney General ruling. So it's real critical. If you get anything, you get any kind of message saying they want records, anyone reaches out to you in writing for records, forward that right away to the General Counsel's office. There are, as I mentioned, there's some exceptions to things under the Public Information Act, things that the public doesn't have a right to access. These include certain kinds of sensitive, personally identifying information like social security numbers, dates of birth. Most people's email addresses are confidential, but not government email addresses. Credit card numbers, certain kinds of health information, and plenty of other things, including privileged information, attorney-client privileged information. So our open record team are experts at this, but they do carefully review anything to make sure that before we release something, that is something that the public has a right to. The more information about Public Information Act, again, there's a handbook and some training with the Attorney General's office, and you can also always reach out to me any questions about that. That concludes the open government training. I'm available to answer any questions.
Hey, this is Lance. I just wanted to test my audio. Can everyone hear me now? Awesome.
And yes, thank you.
Anyone have any questions? Okay, let's move on to approval of minutes, November 13th, 2019 meeting. Board members, you've received the minutes of March 27, 2024. Is there any comment on those? No comment. Could I get a motion and a second to accept them as written?
I make a motion to accept them.
Do you have a second?
I second.
A motion and second to accept the minutes. Anna, could you do a roll call vote, please?
Yes, sir. Colleen Thomas,
Oh, I'm sorry, I couldn't hear you for a second.
oh, it's okay. Colleen Thomas, it's a yay or nay.
Yay.
Lance Thomas,
Yay.
okay. Byron Farrell, presiding officer,
Yay.
and Bruce Ormond.
Yay.
The motion's passed, sir.
Great, thank you. Next item on the agenda is public comment. We did receive one emailed report. All the members of the board should have that. Is there any discussion on it?
Unfortunately, sir, we cannot have any discussion on public comments since it's not on the
Okay.
agenda.
Stephen Leary, Assistant General Counsel, I just wanted to clarify, there was an additional public comment, I believe, that came in this morning. And Anna, can you confirm, was that circulated to the board members?
Yes, it was. Thank you. I forgot about that one.
Okay, so no other public comment. We'll move on. Going on to staff reports. First up is licensing division. I'd like to call on Laura Hernandez, manager, please.
Good morning, board members. I'm Laura Hernandez. I'm the manager in the licensing division. I am here to present the licensing statistics for used auto parts recycler licenses. I provided the numbers for the fiscal year 2023 and then also the first 3 quarters of 2024, as the fiscal year will round out at the end of this month. And so at our next board meeting, you'll have the full statistics for that fiscal year. And I am happy to answer any questions that you may have regarding my report.
Does anyone have any questions?
Now, it looks like our membership or the population has decreased significantly this year.
And we are in the middle right now is the peak season to receive used auto parts recycler renewals.
Okay,
Just because when the program started back in September, back in I think
I got you.
2015. So that number may increase as we may get some late renewals and things like that. So those numbers may fluctuate a little bit.
Understood.
Any other questions? Okay, Laura, thank you. We'll move on to customer service. I'd like to call on Mona Chizun, executive assistant, please.
Good afternoon, advisory board members and TDR staff. My name is Mona Jason, and I am the director executive assistant, standing for Patricia Martinez, who is the manager for this program. And as you can see on your screen, here's our statistic for our phone calls and emails received for fiscal year 2023 and 2024. And that concludes our report. I'll be happy to take any questions.
Do we have any questions?
Is this how many times, I was having a little trouble understanding her. Is this how many times she, the TDLR was contacted by you APR customers? Is that correct? Okay.
Correct. Is the numbers of phone calls and emails.
Okay. Thank you.
Okay, any other questions? Okay, Mona, thank you. We're going to move on to Enforcement Division. I'd like to call on Stuart Baggish, please.
Thank you. My name is Stuart Baggish. I'm a prosecutor in the Enforcement Division, and I'm here to provide you with the Enforcement Division's staff report. To sum things up concisely, closing complaints has taken about 2 weeks longer in fiscal year 2024 than in 2023, and the percent of complaints closed within 6 months, the percentage has decreased about 11.5%. It should be noted that this program in 2024 has seen disciplinary action in just over 5.56% of complaints, which is relatively low, and that's because additional attention has been given to complaints in light of the catalytic converter theft issue coming to the forefront. We spent more time on these cases to ensure the correct result. The next section is the criminal history review for applicants who may have a disqualifying criminal background. These instances are handled by our criminal history prosecutors. I do want to highlight that applications, new and renewal, with a criminal history reviewed by enforcement decreased slightly between 2023 and 2024 from 110 to 105. There have been 0 instances of this type opened by enforcement in 2024, and the numbers reflect that in the separate categories listed beneath. That just means that none of the instances were determined to have merit, which is not unusual since there were only around 100 instances, first 110 in 2023 and then 105 in 2024 of that type to begin with. And it reflects that the class of applicants is improving, which is an excellent development. The next section, complaints received by source, deals with where the Enforcement Division's complaints come from, whether they are from consumers or from within the agency. As you can see, several times as many come from consumer complaints, almost 4 times as many in 2023, and between 2 and 3 times as many in 2024. The top of page 2 breaks down into a pie chart the source of the complaints that were opened in the APR program by the department. 15 are consumer complaints, which is 54%, and 13 are departmental cases, which is 46%. The next section details our caseloads in enforcement, and you can see that caseloads for the department for APR program, as indicated earlier, there were 28 complaints opened, which is relatively low volume, consistent with high levels of compliance. The next section is the orders issued section. This section includes the different types of orders that may be followed in APR program cases by enforcement. There was 1 agreed order and 1 default order for fiscal year 2024 so far, which is common for programs of this type. The next section is the penalties and consumer remedies section, which details how many fines were assessed versus actually collected and shows the average penalty in these cases. Again, there were 2 for fiscal year 2024, as described previously, with penalties assessed being $6,250 and penalties collected being $3,250. So $3,000 remains to be collected. Again, this is not unusual where you have a default. Licenses with disciplinary action is the next section. For this reporting period, there were 0 license suspensions or revocations. The next section is cases closed without disciplinary action, which shows an increase in warning letters from 3 in fiscal year 2023 to 18 in fiscal year 2024, being issued for cases with minor violations by respondents without a serious prior violation history. These numbers are consistent with expectations. The next section details APR alleged violations at opening, which is the basis for the case being opened to begin with, and the reasons are listed in the report. We've seen a decrease in the amount of unlicensed activity, which is a very good development. The following section details APR violations which resulted in disciplinary action, which is the basis for the case in which we took disciplinary action, which in fiscal year 2024 was a total of 4 cases, compared with 5 such cases in fiscal year 2023. Again, these figures reflect a decrease in the amount of unlicensed activity, which is a good development. The case highlights that we have for enforcement involve the Alpine Used Auto Parts case, which is APR 2021-0007858, and that involved an agreed order that was entered into on September 27th, 2023, where respondent accepted an administrative penalty of $3,250, which we discussed earlier. Respondent failed to maintain records as required and to provide them to law enforcement on request for multiple transactions at Alpine Used Auto Parts. This penalty was a combination of several violations. The other case highlight is GD Star Auto Salvage LLC, which is case number APR 2022-0017-083. And that case is a default order that was entered on April 6th, 2023, where respondent was ordered to pay an administrative penalty of $3,000 for operating an unlicensed automotive parts recycler facility. The respondent has begun making payments, but still has an outstanding balance with the department. Overall, compliance has improved and prioritization of violations has played a vital role in this accomplishment. That concludes my enforcement report. If you have any questions, I'm available to answer them at this time.
Do we have any questions?
No, good information.
Hearing no questions, thank you for your time today.
Thank you,
Stuart.
Stuart. Appreciate it.
Move now to the Compliance Division. I'd like to call on Michael Strawn, please.
Morning, presiding officer and members. My name is Michael Strawn. I am the manager for our compliance division, specifically for our consumer protection section. I'm here to give you the updates. First, we're going to have personnel updates where I'm going to talk about myself. I'm the new manager for this program and came over here in February of 2024. So about 6 months now, I've been on the job. We currently have been involved, as you're probably going to hear later, in some of the program updates for rule packages and everything else, but heavily involved in Senate Bill 224 that came out of our 88th legislative session. This bill requires us to work with the Motor Vehicle Crime Prevention Authority, MVCPA, DPS, and Texas DMV as well to combat catalytic converter theft. Effective June 25th of this year, we were able to successfully enact an interagency contract that was fully executed between all parties. That contract's actually up for renewal at this point in time, and we are going to renew that for the next fiscal year. What this contract is going to do is going to provide TDLR the ability to hire 4 full-time equivalent positions for our field operations to perform increased inspections of APR facilities. Additionally, what it's going to do, and we'll add an additional staff member to our compliance section, our compliance division, which will be our APR liaison. This liaison is somebody we expect to greatly benefit not only the department, but other agencies and licensees and the public all together. This liaison will work not only on SB 224 for reporting, collaboration between interagency task force, group meetings, but also working with our licensees out there day in and day out to figure out what struggles are they running into, what rule changes need to happen, how we can make this industry tighter and run more efficient, and reduce crime that potentially targets this area as well. So this APR position will be very important in the coming days, and we're working to post that position here quickly. And then, of course, the outreach. Recently, we, along with other state partners and VCPA, have visited metal recycler entities and auto parts recyclers in order to collaborate, get ideas for the roll packages that you'll see later today, and learn a little bit more about the day-to-day operations of these entities across the state. With that being said, that is my updates for this advisory board, and I'm open to any questions you may have.
Do we have any questions?
I do. I noticed you say inspection of APR facilities. Is that supposed to be UAPR?
So internally, we refer to all of our programs with a 3-letter acronym. So auto parts recycling, while statute does have used auto parts recycling in it.
I was just making sure we had the whole acronym, whether it was changed or what. Okay, I just clarifying on that.
Yes, sir.
So the idea is to perform more, and when you say enhanced, what is that implying?
So yes, the agreement calls for more inspections. When we say enhanced, there may be increased measures that come of the rule packages. As the rules are not final and there are still procedures being laid out, those are not finalized at this point in time.
Are these risk-based inspections or just random inspections, period?
So you're going to get into that, gets into the discussions and operations for our field operations division, and I would hate to speak for them on what that looks like on everything there. I do believe we have somebody on the call from that side.
Okay.
Yeah.
Any other
Mr.
questions?
Yeah. Chris Russi, Field Inspections Director. I'll talk about that here. I got my staff report next. So if you'll hold on a second, I'll be able to answer all your questions.
Okay. If there's no other questions, we'll move on to field inspections. Call on Chris Russi and Ulysses Oasis. Sauce seal, please.
All right. Thank you, Chairman. Good afternoon, Chairman and board members. My name is Chris Russi. I'm the Director of the Field Inspections Division for TDLR. As you'll see here is our statistical breakdown for the past 2 fiscal years, fiscal year 2023 in its entirety, and then fiscal year 2024 through the 3rd quarter, or through June, actually. So 1 month into that 4th quarter. Below that, we go into our current projects. So like Ford did, I'm going to talk about myself a little bit. Effective October 15th, 2023, I became the Director of the Field Inspections Division. I actually previously had Ford's job. And so after I received this position, Ford ended up getting my old job. In July 22, again, it's been a while since this advisory board has met. TDLR and Field Inspections Division began using in production a electronic inspection system. For those that have been receiving inspections for a while, you probably remember our old triplicate forms with the carbon copy and all that. Nowadays, we've moved on. We now have an electronic inspection system that we've been utilizing for a couple of years now. The efficiencies are obviously much greater with that, and it's been going great so far. The last little bullet that we have here is regarding Senate Bill 224, and Ford covered quite a bit of it a little bit ago. Part of that is the interagency agreement that we have with the Motor Vehicle Crime Prevention Authority, which includes DMV and DPS as well. Mr. Thomas, I know you have some questions about the inspections and what that's going to look like, so I can certainly take those right now.
Yeah, just, when it says increased and I don't remember what the other term was, but
Enhanced.
what enhanced? What does that mean? Is it based on risk? Is it risk-based inspections, or it just, we're talking about more random inspections, period, or what's the goal here?
Absolutely, Mr. Thomas. So all inspections right now for the Field Inspections Division are risk-based. Previously, prior to our sunset review, actually, all programs were subject to periodic inspections, and that periodic time frame was listed in the rules. Now we've gone to risk-based, and so we get to decide how often places are inspected based off of risk relating to prior disciplinary action, violations we find, and then external factors. With this, for example, is going to be Senate Bill 224 and this agreement that we have with the Motor Vehicle Crime Prevention Authority, which actually requires increased inspections. Now, as far as enhanced, we have been doing a pilot program with this. Of course, the statute, it does require some record requirements relating to catalytic converters. And then the proposed rules are the things that y'all are looking at today, and they clarify what that record keeping is going to look like. So what we've been doing is going out with the proposed rule package, and we've been trying to do like a little bit of a education and solicitation at the same time. You know, talking with the businesses. Hey, these are the rules that are being proposed. What do you think? What is this going to look like to implement to y'all? Not only were we able to get some engagement from the stakeholders and licensees and their thoughts on the matter, but we were also to kind of gauge what would this look like on timelines for my inspectors. You know, currently on an APR inspection or UAPR inspection, it takes about 30 minutes. However, if we're going to look at additional record keeping requirement, what is that going to look like? Is it an hour, 2 hours, 3 hours? And so again, these are all educational components that we were talking about with the new requirements, because again, that's what this meeting is for. It's for y'all to review them and to vote on them. And so any enhancement in inspections is going to be a direct relation of what y'all do with these proposed rules.
Okay, thank you.
Mm-hmm. If anyone else has any other questions, I'm certainly happy to take them as well.
So we originally, I'm sorry, go ahead, Byron.
Oh, go ahead, Bruce. I'll do mine after yours.
When we originally came to TDLR, we were set up on biannual or inspections every 2 years. That got changed to 4 years. So are you saying now, Mr. Rusty, that y'all can set it up to whatever time frame y'all want at this point?
Yes, sir. That's going to be created and based off of a few different factors. You know, one of them, in general, it's going to be increased. So I can tell you it's going to be more than every 4 years, you know, because that's just a requirement of the bill and with our agreement between the different agencies. But there's not going to be an exact time frame, and that's kind of the value in a risk-based inspection, is that we get to base it off of previous inspections of that business.
Okay, correct me if I'm wrong. Senate bill addresses inspections with TDLR. Senate Bill 22.
It doesn't, but in our implementation of the bill, there was a work plan that was created with the Motor Vehicle Crime Prevention Authority, and within that work plan, it described expectations of the different agencies, DPS, DMV, and TDLR, and general expectations and how the bill would be implemented.
Okay.
Okay, I do have a question too.
Stephen Larry, Assistant General Counsel. I just wanted to clarify a point about Senate Bill 224. And I can go and share that up, the part that deals with this. But there's a part of Senate Bill 224 that required a plan between the agencies. And that plan was required to address enabling the agencies to effectively respond to catalytic converter theft and to share information. And as part of that plan, we were required to identify red flags or issues that would be a sign of possible illicit activity. So it is in the bill, and so it's indirect. There's the bill, there's an interagency plan that was finalized under the bill, and then there's our participation in that plan, which included the interagency contract. So just a little bit of nuance there. I'll show you, you have up now the bill itself. You'll see in Article 5 of the bill, it's coordination of state agencies to detect and prevent theft of catalytic converter. See in 501B, it required this plan to be developed and implemented by January 1st, which coordinates the efforts between the agencies And I required that plan to involve reviewing of the records regulated by each agency and to respond to suspicious activity. So I just wanted to shed light on that. There's the bill itself, there's the plan that was required to be formalized under the plan, which that plan is in effect. And there's the interagency contract, which is called for in that plan. So there's a couple of layers to that.
Thank you, Stephen. Chairman, you had a question?
Yes, if a UAPR entity has a license and then that license expires and is not renewed, does TDLR go out and verify that the business is shut down or that it's not engaged in UAPR, or how does that work?
With our risk-based plan, they still will be on our inspection list. Excuse me. Until we go out there and we have an out of business inspection, and then we will change that license status within our licensing system. As you know, typically if someone goes out of business, they're not going to send their license into TDLR and say, hey, I'm not operating anymore. We will go out there still on that list if they've been expired within the previous 18 months.
Okay, anybody else have any other questions? Okay, thank you. We'll move on to Executive Office. I'd like to call on Brandy Myers, Deputy Executive Director, please.
Thank you so much, Presiding Officer and board members. My name is Brandy Myers. I'm the Deputy Executive Director over the Administrative Services for TDLR. The first thing on my list is personnel updates. Since the last time you've met, the Executive Office has completely changed. And so I wanted to start off with letting you know who we are now. So first and foremost, we have Miss Courtney Arbor. She is our new permanent executive director. She comes to us from the Texas Workforce Commission, where she was a workforce development director and was responsible for implementing workforce education and regulatory programs that had a goal of developing and protecting and connecting employers to workers. She has been here since June 3rd. So she's about 2.5 months in. She's doing a great job. And she did want to extend her apologies to this group for not being able to make it to be here with you today. She was called to the Capitol for another meeting. So she's doing her executive director thing today and unfortunately wasn't able to join you. But we're glad to have her as our executive director. Next, I want to talk about Steve Bruno. Some of you may know him. He is, or was, excuse me, our legislative director for TDLR. And he is now our deputy executive director over our licensing services. So he is over the customer service, licensing, and exam and education divisions within the agency. So he is doing great in that role, and we're excited for him as well. And just quickly about me, I am not new to the agency, but semi-new to my role. I've been here over 5 years. I came to the agency as the Chief Financial Officer and became the Deputy Executive Director over Administrative Services November 1st of last year. So there's a whole new group in the executive office, but I can tell you that every single one of us are really excited to be here and to be able to support our advisory boards in anything that you may need. So thank you to all of you first and foremost. For the next item on my report, I have the bill implementation update, and I'm going to lovingly skip that because I don't want to take away from Mr. Leary's presentation that's coming up next. So I will move on to the strategic plan update. This is the report that we did that talked about our agency goals and our initiatives that we were going to be looking into for the next 5 years. This report was submitted back at the beginning of June. And then as a part of that, the next piece that usually comes from that is our legislative appropriations request, which did. We got the instructions for that report at the beginning of August, and it was actually due, we got the instructions at the end of July, and it was due last Friday. So we've turned that in, and so we've got all of our legislative reports where they need to be. We're excited to have those wrapped up, and then the next part will start to come with hearings, and as we get into legislative session moving into January of next year. So those are all of my updates, and I'm happy to answer any questions.
We have any questions? All right. Thank you, Brandy. Appreciate it. We'll move on to item G, discussion and possible recommendation on proposed amendments and existing rules. I'd like to call on Stephen Leary.
Thank you, Mr. Presiding Officer. Stephen Leary, Assistant General Counsel. For this item, as part of the bill implementation process, we pieced together the bill implementation team, which includes people from different departments within TDLR. We pieced together some draft rules. Now, I want to clarify that these rules weren't just on the topic of Senate Bill 224. So I had considered having a separate item just for catalytic converters, and because the packet was relatively short, we combined them all into this one item. So what I'm going to do, I'm going to share up on my screen the draft rules that was circulated to you. I'm just going to kind of walk through what those proposed items are. I understand some of them are controversial. We might go a different direction, but I'll walk you through them. And for the rule about catalytic converter theft prevention, we had a summit this morning that was dedicated to that topic. Based on the feedback, anticipated feedback, I have also drafted an alternate version of that rule that, if we need to, I'll present that. And that one is simply tracks the language from the bill as far as record keeping. It doesn't have these additional record requirements that were somewhat controversial. So I'll walk you through what I circulated to you. We'll go through it. And while I'm going through this, I'll pause at each item. Each rule that's being amended, I'll pause. And if you have questions about that, you can jump in. If you want to hold your question until the end and also ask your question after I've walked you through it, that's fine too. I'm going to go ahead and share this on my screen. Okay. And I'm sharing the wrong version. I wanted to share this other version. Okay, very good. So do you have on your screen the
We
the
do,
draft rule?
Stephen, but can you zoom in a little bit?
Yeah, we'll do.
My eyes
We'll
are not
do.
that good.
Okay, very good.
Perfect. Thank you so much.
All right, great. So the first thing and this is a cleanup change. This really wasn't, well, it's kind of a mixed bag. So Rule 87.1, that's our rule that deals with authority, the authority that we have to adopt rules. As you'll note, the new language is being inserted throughout this thing. The new language is underlined. Language is in the rule now that we're proposing to take out will be in cross through. It'll be strike through. So what this does, it has a paragraph about authority and applicability. And the reason why I'm proposing in Part A to cross-reference these other statutes, well, a couple of reasons. Some of the rules that we currently have implement parts of Transportation Code 501 having to do with casual sales and records that are required by the DMV. There's a requirement under our statute to keep those records. So we want to make sure that, we're implementing the primary purpose of these rules is to implement Chapter 2309, which is our statute that's specific to used automotive parts recyclers. We're also implementing our authority under Chapter 51 to regulate regulated programs. But we also, I wanted to cross-reference in here the requirements under 2305. The new requirements under Senate Bill 224 that had to do with the records that you APRs have to keep. Those are not in 2309, they're in 2305. So I wanted to cross-reference those requirements because they're also applicable to this program. And the current program rules, the current Chapter 87 rules, don't make any mention of 2305. This bit in Part B about the Chapter 60 rules. Those are rules that the Commission has adopted that apply to every program. And they include things like license renewal, or some provisions about contested cases, open meetings. Those Chapter 60 rules are designed to apply to every program. So this is sort of boilerplate that we try to include in every program rules, just to let anyone who reads those rules know that in addition to having to follow the Chapter 87 rules, you also have to follow the Chapter 60 rules if those apply to your situation. So Chapter 60, you're already subject to that, but this is letting everyone know that those rules also apply. I'll pause there. 8710 definitions. This was a rule review item. It was pointed out that in our rule, there's a statutory definition of an off-highway vehicle, and that definition is cited to a part of the transportation code that's been moved. So 502.001 of the transportation code, the definition for off-highway vehicle is no longer there. It's now in a new chapter 551A. So we've corrected that reference here. And so I would call that a cleanup item. It was suggested as part of the 4-year rule review process, or it used to be RPM, or Regulatory Program Manager, which is now called Compliance Division. They pointed that out and wanted that changed. In the definition of used automotive part in part 15, I had added a sentence, or proposed adding a sentence here that the term includes a catalytic converter. And it's been pointed out to me that that's really not necessary because it already is a component part. I propose adding that for clarity purposes, that anyone looking at this would know that a catalytic converter is something that we regulate. It is a used automotive part. So I was proposing adding that for clarity. It's not critical, but just adding it for clarity. 8710, this is getting into the license required. And this is an interesting thing. So in the statutory provisions about licensing, it tracks this current language in 8720A that you can't operate as a used automotive parts recycling business or sell used automotive parts without a license. The agency has taken the position that people who sell used automotive parts, but who are not engaged in dismantling vehicles or disposing of vehicles, don't require a license. And I think the rationale behind that is that the definition of a used automotive part recycler includes those elements. It includes the removal or dismantling of vehicle parts and the sale of the parts and the disposal of the vehicle. So someone who just wants to sell parts, to sell used parts on eBay, on our frequently asked questions on our website, we've taken the position that that's not used auto parts recycling, just selling the parts. That might be a better item for legislative cleanup, or maybe we ought to leave that alone. But right now, the way this rule reads, that or sell used automotive parts, is inconsistent with the agency's position and what position the program has taken. So that's why I propose striking that language. We get into that. 8771, this is the rule that deals with record keeping. I had suggested some change of this for 2 reasons. The first reason is for clarity, because the way it's currently written is somewhat confusing. Under the current rule and by statute, there are different lengths of time that a UAPR has to keep records, depending on what kind of record it is. So what we call street parts, or a UAPR who purchases parts by themselves, individual parts, the statute requires 1 year. You have to maintain record of purchasing the part. But records of casual sales and other records that are required under Chapter 501 of the Transportation Code, the current rule requires 3 years you have to keep those records. I'm proposing changing this language in Part B, or subsection B, because right now it reads, unless required by another section. It's a little unclear. I think what we're really saying here, unless a shorter period is required by another section, the general rule is that you have to keep the records for 1 year, or for 3 years rather. So that's just a clarifying change there. Now in subsection C, we have a specific reference here to 2309-356, which is the records of component parts. And that is a 1 year retention period. That's by statute. In subsection D, I had designed this to correspond with the catalytic converter theft prevention rule, which we're going to go into more detail. But to put all those record keeping periods and requirements in one place, we wanted to reference that rule. Now, under Simple 224, the records that are required for catalytic converter sales have to be kept for 2 years. So we wanted to cross-reference that requirement. It's a 2 year requirement. Part E, One of the comments that came in during rule review is that the compliance department wants to make sure that the requirement is clear that for any of these records that UAPRs are required to keep, that you also have to furnish those records upon request by an inspector or investigator. So we want to make sure that's in there so that if a UAPR doesn't produce the records that they're required to produce, part of our initiative under Senate Bill 224, our responsibility is to examine those records and verify those records. So we need to make it a requirement that you produce those if we're asking you to produce them, and let us copy those records. So that's why we put that. That was a rule review comment, but it also dovetails into the catalytic converter issue. 8772, this was a rule review change, and it's just to make sure that UAPR has to notify us of a change in contact information. We want you to update us your contact information within 30 days, and that can include a mailing address, phone number, email address. Different programs have a different number of days of grace period to notify us, but 30 days is pretty standard. 87, and so we're renumbering everything else if we add that in. 8778, removal of license plate and registration insignia. I got some comments about this, and I want to clarify. So this will also be an item for statutory change, but the current statute in 2309-352, it requires UAPRs to remove an unexpired license plate. Well, the problem is that's outdated language. In the current system that DMV has, license plates themselves don't expire. They actually haven't expired since the 1970s. Originally, license plates had an expiration date. You get a new license plate every time you renewed your registration. Then they went to this plate sticker system where the sticker's on the plate. Now we have a system with a windshield sticker. So our licensees are confused about that requirement to remove unexpired license plates. They understand you got to remove the license plate, but there's confusion about, well, do you also have to remove that registration stickers on the windshield? Our inspectors will go out and they'll see those registration stickers on the windshield. They'll say, hey, you need to remove that. Well, where does it say we have to remove it? It says we have to remove the license plate. So to modernize that and to clarify that, we want to put in rule that in addition to removing the license plate, you also have to peel off the sticker. You can't have the sticker on the car. That's also something we're looking at for a possible legislative fix. It's not a high priority, but it's something that's brought in some questions and concerns. 8781, that was our draft catalytic converter theft prevention rule. And, we had extended discussion about this item during the summit. I don't want to belabor the point. I'll just sort of go over what were the items that we wanted or that we were considering requiring. And then I'll also go over the alternate version of this that I had drafted that watered this down and made it, took out some of the more controversial requirements. We can also talk about that. So the way this was written, UAPR couldn't have catalytic converters that are taken off the vehicle. It says dismantled or removed, and there's some finer point of what it means to dismantle or remove. But basically, if you're going to take catalytic converters off a vehicle, you have to comply with this rule. If we go and inspect a business and the catalytic converters aren't on the vehicle, they're in a bin somewhere, they're removed, they're in a situation we don't know where that catalytic converter came from. The idea was you have to comply with these rules. And it required tagging them. So you had to maintain inventory of where those catalytic converters came from, the VIN of the vehicle origin. We wanted to require inventorying so that you would know, you'd be able to track these things. We also wanted to require a record log that we could inspect at any given time. We know what catalytic converters you have and where they came from. As far as sale or disposition, this required keep a log, and it would have to be in a form that we approve, so we'd be able to readily inspect and audit this, that would show who you sold it to. Now, already, if you're going to, buy individual parts, there's a form for that where you're supposed to verify the identity of who you're buying it from and check their driver's license. But this expands that so that whoever you're selling it to the metal recycling entity, you would have to keep track of who you're selling it to. The statute requires a name, but this goes beyond that. It requires identification. A lot of things about this. It brought considerable discussion during the summit, and then I think I don't want to predict whether or not they're going to happen or not, but based on the feedback, there are some considerable concerns from industry. There's some considerable concerns from the advisory board about those requirements. They do go well beyond what 2305 requires. 2305, we talked about that at the summit. It requires that you maintain a record when you sell or transfer the catalytic converter, a description that's in accordance with the custom of the trade. So it's not necessarily saying you have to keep it in a particular format. There's a revision in there that says that if you keep it in the way that you usually keep it, that satisfies that rule. And this is going beyond that, but there are reasons why we wanted this. Reason staff recommended some of these changes was this general concern that when they go to inspect a business, there'll be a bunch of removed converters. They'll have no idea where they came from. All they'll really be able to track is how many there are. And it's just not really clear what kind of record keeping you're going to have or how you're going to produce it. If you're going to produce it in a way that's readily trackable, traceable, and understandable. So that was kind of the rationale behind that. And I understand the rationale behind why that was controversial. I want to share an alternate version of that catalytic converter rule that I also drafted. And so I'm now sharing an alternate version of 8781 that we might also consider. And what it does, it basically tracks the language of 2305. It says that upon sale or transfer, which is a term in the statute, you have to create a transaction record. The record has to have, and these are the elements that are in the statute, the name of the person you sold it to. And person, once again, it doesn't mean individual. Person means an individual or entity. The description of the catalytic converter sold, the day of the transaction. It incorporates this language from the bill that the description has to be made in accordance with the custom of the trade or volume of catalytic converters sold or transferred in the transaction. We would like that to be a little clearer because, I think to someone reading that rule or someone trying to enforce that rule, it's a little bit unclear what is the custom for the trade. I've heard in comments that typically these things are weighed or sold by weight, not by individual. So we can talk about that. Part C says that you have to keep those records for 2 years. Well, 2 years is what was in the statute for how long you have to keep those records. And it says that you must produce them for inspection. Now, the reason why we want this at all is that although 2305 requires those records to be kept, and it also has in there that we can inspect for them, and it creates this misdemeanor offense if you don't. There's not a real clear tie-in in our current rules for being required to do that. So I've gotten questions from our enforcement division about, 2305 is currently on the books. Now we go inspect a place and they're not keeping those records or they're not giving them to us. Can we enforce that? Can we issue a notice of alleged violation? Does that currently violate the statutes and rules that we enforce? Because that's not very clear, we want to at least have some type of rule that incorporates the requirements that are already in the bill. So at this point, I'm opening myself up to any questions.
With the maintained description of converters sold, what does that mean? What would be the interpretation of maintain a description?
I think that was kept vague on purpose. That's the language from the bill.
Okay.
And I think probably the reason why that's in there is because depending on how many you're selling, you're in a particular industry. So that provision applies to used automotive part recycler, also applies to metal recyclers and to repair facilities. That provision is subchapter D. So you would know better than I would what is custom for the trade or industry. And that's something advisory board can weigh in on. We may want to refine that definition. I understand from comments I received that these are typically tracked by weight. When you sell these to the metal recycling entity, the invoice or the paper to document this. It may not say how many catalytic converters, it may say how many pounds or tons of catalytic converters, but you would know better than me. The idea at this point was to track the language of the statute.
Right. Yeah, so some are sold by the piece, some are sold on assay when they are sent out and decanned and all the catalysts combined and then melted down. But I would say, like for my sites, every car is issued a stock number that's tied to the VIN number. And we, basically my guys, as they're removing converters, they write that stock number down, how many converters were removed, how many were not able to be removed, and how many were missing. And once that converter goes off, it just goes into a locked bin. So it cannot be, accessed by anybody but management. But that is all of the, tracking or maintaining that we do. And again, we don't buy. And honestly, I'm not saying this candid, I want to be careful with this, but I would say a lot of the people that will risk buying individual converters are probably the people that, are going to be, the higher risk audited individual, licensees. So.
Hey, Lance. Also piggybacking on that, and this is for Mr. Leary as well, mainly, the stock number is everything. So I'm getting the feeling that obviously there's a level of compliance for MCPA, for MVPCA to have some form of records that or some way of doing this. If we're required to write the stock number down on each catalytic converter, that way when we're inspected and your inspector goes to our stack and says, where did this come from? With that stock number, we have record of that vehicle and it's in our system. Just like in our rules, we put in there where upon inspection back in 2009, that your inspectors can go on my yard anywhere, grab a part off the shelf, and I have to verify how I came about that part. And they walk out and do the same thing with the vehicles on the yard. And I have to bring up record and documentation, whether it be the title or auction papers of where I purchased that car. So this would be the best way, because there's no effective way. The truth of the matter is, if I was doing illegal, I could sell half of my converters. Y'all would never have any idea. I could sell them to the black market and y'all would have no clue of that. This is about the inspection being effective. And like I say, if we have the stock number written on there, then it is identifiable and trackable all at the same time. You not only track the part, but you also track the car that was purchased and where the car was purchased from. And so that's how I see that would be the best way. And records retention is when we sell those catalytic converters, that we just keep a copy of the invoice that's inspectable. So if upon inspection, whether it's TDLR or any of the other law enforcement groups, then we have copies of our invoice where we sold them. And that's about as well as you can possibly track them, because skirting any of these rules is really easy for anybody that's not wanting to be compliant.
Yep. Yeah, and that's what I would agree, Bruce. I have no problem. Well, I do, because it's still adding steps. And again, with the labor force that we have now, it's hard enough to get them to follow, our basic policies and procedures and make sure that we stay compliant.
It will be a huge disruption. I'm sorry. Go ahead, Lance.
Yeah. No, I'm just saying it wouldn't be a huge disruption, but again, what's the purpose in adding it just to add it? Because the people that are not, that are doing this stuff illegally are just going to assign a legit VIN number or stock number to that catalytic converter. And so we're not really accomplishing anything by any of these requirements, because the people that are going to do it illegally are going to cheat the system regardless and not get caught. There's no way that inspector is going to show up and be able to argue that converter did not come off of that VIN number. You know, they just look to make sure that they got it identified, yada, yada, yada. And he showed that he connected it to that vehicle and they're going to go on. So I don't think we're really accomplishing any purpose here by adding any of that to, you know, to the wording.
Yeah, that's the heartburn is it's not really accomplishing their goal. And by requiring the stock number added on there, then upon inspection by any law enforcement, then we can produce all the data and information they need at that time.
Stephen Leary, Assistant General Counsel. Hey, General, I just want to throw this in here for additional information. I'm sharing on the screen the DPS rule for metal recycling entities for marking of catalytic converters. I just want to share that kind of served as the inspiration for this draft or this concept of marking converters. I understand it's a different industry. They probably have different challenges, but when an MRE receives a catalytic converter, they're required to mark it that kind of way. They mark it with a unique number, with the date of the transaction. And so I just want to share that with you. That was some of where that idea came from. We were sort of
So Stephen,
in some ways mirroring that rule.
Yeah. So Stephen, Lance Thomas here. I think too, also a converter buyer is an MRE, and there is no way that they can tie converters to VIN numbers that they're purchasing. And so I don't know how they're meeting that requirement, you know, in the first place with that. And generally, you know, an MRE such as a actual shredder or a scrap buyer, I would say, are going to be buying individual pieces. And I could understand like trying to regulate those because those have the highest potential of being stolen. But again, it's just too easy for someone to cheat the system, you know, and tie it to another VIN number that they bought.
Okay, this is Byron. We've got a lot of information that's come in between the summit and this meeting. Would we be smart to put together some type of work group to try to clean all this up and get it worded correctly to where we all understand everything and can kind of put together a program for ourselves to make all this happen, or what we can happen or can't happen? I just think a work group would help us to clean all of this up, whether it be legislation or catalytic converter. That's my thoughts. Anybody else have thoughts on that?
Yeah, I agree. I mean, and I do think like there needs to be some kind of basic reporting of that, because a lot of this stuff, you know, and you guys know, a lot of this can turn into very high dollar cash transactions, especially, you know, when you're dealing with on the illegal side. And so, you know, if there's not any kind of reporting at all required, then it's very easy for someone to, you know, to sell a large volume of converters without it being documented whatsoever. So, I mean, I do agree kind of at least a minimum kind of where I'm at, and, you know, or somewhere in between of documenting what's coming and going. It's just going to be very hard to get it down to the individual level.
I have something else I wanted to maybe point out. I don't want to break from this subject, but I had something that had been pointed out early on some language change under 87.20 under A, where it says a person may not own or operate a used automotive parts recycling business, and then the words were struck out, or sell used automotive parts without first obtaining a license under this chapter. So, you know, I don't have it here.
Oh,
Looks like Mr. Ormond froze.
yeah.
Sell used parts if it's.
Bruce, we lost you for a minute.
Okay. So, in the original language, there is provisions for people to sell used auto parts if it's incidental to their business. But if a person is running a business and it's more than incidental, they should have a UAPR license, because the only way they are obtaining used auto parts in volume has to be whether they're licensed or not, they have to be attaining these parts somehow in volume. And so
Yep.
that's why that language was put in back then. If it's incidental, guys at home, he went and bought, he's driving a 2022 Ford F-250, and he goes and gets a lift kit and tires and wheels. Well, he should be able to sell his tires and wheels with no problem. That was why that was in there. But if a guy's constantly listing on eBay or, Craigslist, and then he needs to be licensed. Whether he's licensed or not, he is a used auto parts recycler.
Yeah. And that has been an issue, even here in Waco, where customers are dismantling vehicles out in the country and selling parts in a downtown facility. And I don't know how they're getting their license, but they're not, there's no stormwater or anything like that for it, because they're in a downtown building, but that's not where their main operation of dismantling is occurring. So I think, I had that noted down also. I think that needs to stay in there, or we're going to open up a pretty big gray area.
Yeah, agreed.
Ms. Byron, Stephen, would it be smart or prudent for us to put together this work group and kind of clean up all of this information? I mean, this is quite a bit of information to go through in one time and to try to make a decision on, I believe. So could we have a work group that kind of works through this and gets it to where we all understand it and all can manage it and then could vote for it? Is that something that would be prudent to do, you believe?
Stephen Leary, Assistant General Counsel. Yes, you may appoint a work group and assign this to a work group, and that would be proper. Then we would have another advisory board meeting. Once the work group has put together its report, made its recommendations, you would present that at the next advisory board meeting. On the point about or sell used automotive parts, it sounds like there may be some inaccuracy in the languages on our current website. There's a frequently asked question that asks, if I just sell automotive parts, do I need a license? That says no. That is something that from our discussion today may need updating. So I will look at that. We want to make sure that on our website we are putting forward accurate information. And so I appreciate that feedback. And yes, if you want to assign it to a work group, that'll be the procedure, as the chairman would appoint a work group with less than a quorum. And then we would schedule a subsequent advisory board meeting.
I think I would. I think the smart move here would be to appoint a work group right now, and let's kind of work through this and get it all where it needs to be and where it's easy to understand, and we can all get behind it and get it done. I don't know exactly what I need to do that. How does that work?
So for this work group, because this is a very small board of 5 people, the number has to be less than quorum, and quorum is 3. So we would only be able to have 2 board members on this work group. But Mr. Farrell, you have the power to appoint people to the work group. You can appoint yourself to the work group as well, but it can only be 2 people.
Okay. Lance or Bruce, would either one of y'all want to do it? Would both of you want to do it, or would rather me be one of them? How would y'all want to do it?
Whatever y'all decide, I'm happy with.
I'm here to help. So whatever.
Okay. Well, if I could, if Bruce and Lance are both in agreement, I would point them to the work group.
Okay.
And let them try to work through this and get it worked out for the advisory board.
Okay. Stephen Leary or myself will reach out to Mr. Ormond and Mr. Thomas to schedule the work group meeting, and then we'll schedule an advisory board meeting after that.
Okay.
Stephen, I'm not sure, but do we need a motion to table this item until the next board meeting?
Stephen Leary, Assistant General Counsel. I don't think so. I think you can make a motion to appoint the chairman can appoint the work group, and I think it would probably be a good idea to do that.
To table it, or?
Yeah.
Okay,
Well, I don't think it's strictly necessary because you're not taking action on the item, but
Sure.
it would make sense.
okay.
Ms. Byron, could I have a motion and a second to table?
I make a motion to table.
Do you have a second?
I'll second.
Anna, could you take a roll vote, please?
Yes, sir. Bruce Ormond,
Yay.
Colleen Thomas,
Yay.
Lance Thomas,
Yay.
and presiding officer Byron Farrell.
Yay.
The motion passes.
Okay, we'll move on to item H, recommendations for our next meeting. I think obviously this cleanup and catalytic converter going to be one of the top items for discussion at the next meeting. Does anybody have any other items?
Yeah, and I'm new to this, so tell me if this is not possible. For me, just in the volume and stuff that I buy, the looking at where TDLR is with like a digital license or e-license type system versus the mail-in, which I think is still what's ongoing now. And then I don't know if there's anything we can look at from the UAPR side for the properly assigned titles, which would enable us to be able to compete with some of these illegal operators if they have the title to the car, even if it's not properly assigned. And then the big thing for me is the issues I run into buying VSF paperwork from tow companies that's incorrect. And then I send it in and it gets rejected at DMV and then put back on us, and the tow companies will not fix it. They'll basically just stop selling to me. So,
Lance, I can help you on the last one. We worked with TDLR closely on this early on because about 85% of all BSF papers won't pass that. And what we agreed on was just to keep it in the month. You know how we keep record of the cars we turn in on the VTR 340 is just put your paperwork in with that month that you bought those cars. That way, if you're inspected, you can go back and show proof of the purchase there.
So the
Steve
paperwork,
Miller,
if it gets,
Assistant General Counsel, sorry to interrupt. I just want to make sure that we don't engage in a discussion an item that's not on the agenda. At this point, I
Okay.
believe we're proposing
Agreed.
items for the future agenda.
Call me, Lance.
Can y'all share that info with me too, please? We have that same issue with the auction paperwork.
So that would
Okay.
be walking quorum if we
Oh.
have, if we all talking about it. But Mr. Armand, if you can send me the information, I can get it to every board member.
Okay. All right. I'll email that to you then.
Thank you, sir.
thank you.
Okay, any other items for future meeting? Okay, we'll move to discussion of time, date, and next meeting. Would it be easier, Anna, if you polled the advisory
Yes.
board to plan the next one? Is that the smart way to do that?
Yes, sir. We'll probably do it after the work group has met and written the report and everything like that. And give Stephen some time to work on the proposed rules after that work group meeting.
Perfect.
So yes,
Great.
I'll pull it.
That'll take care of that then.
Did
Okay.
we lose Mr. Farrell? So your camera is off.
Okay, is it better?
Better, thank you.
Everything's freezing up now.
It says it's time to leave.
Definitely. Okay. I'd like to go ahead and adjourn this meeting at 1:15, please.
Thank you so much, sir. I appreciate it.
Thank
Everybody,
everybody for y'all's time.
Thank you.
Thank you all. Appreciate it very much.
So good work done today.
Thanks.
Bye, everybody.
Bye.
Bye.